I didn't realize that collection agencies had to be licensed. Are you regulated by the DBPR as well, or who regulates you?
Very, very good. And well, we're going to be Florida specific right now.
Okay.
Primarily, I am responsible for the Fair Debt Collection Practices Act to the FDCPA, which is run by the Consumer Finance Protection Bureau. That's federal statutes. But there are also, in many states, Florida, they have their own consumer protection agencies. So I have to adhere to Florida statutes as far as debt collection is concerned, as well as federal. However, I will say that in most cases, in most states, including Florida, the laws parallel each other, the Fair Debt Collection Practices Act. However, every state is different, and Florida is different. I guess if you're following the legislature, this past July 1, a new law was signed by the governor, and that law required community associations to give an additional notice of delinquency before they're sent into collections. So managers out there, before you send anything into collections, look at your process, make sure that you change your process as of July 1st this year to have that additional notification. What we did over here at Axela is we included that typical notification in the initial demand letter. So if community association or management company did not adhere to that, we will cover them on that particular requirement.
So it takes a lot less pressure off the board and off the manager when working with a collections agency, I would think.
Oh, incredible amount of pressure it takes off. Well, first of all, the board shouldn't be involved. All right. The board is a volunteer group, and they should set the rules and regulations and the policies and let the management company do their work, unless, of course, they're self-managed and they're doing it themselves. So yes, it takes a tremendous amount of administrative work off the management company, who often do not budget or do not calculate this when it comes to their pricing with the community associations. When they're trying to acquire them for the first time, they don't say, oh, if somebody goes delinquent, this is what it's going to cost. With our program, management companies can engage delinquent owners and can even, we have sort of like a white label program where if you're with XYZ management company, I can make you out a brochure, and we have an agreement which is called Management Direct, where the management company can, white label this, and it looks like they're doing all the work, even though we're the ones who are licensed, and they're totally indemnified. But let me give you a great example. Somebody's in collections, and they call you up, your management company. Now, when somebody calls up a management company, it's usually for a facilities issue. There's somebody in my parking spot, there's a dog off the leash, something's going wrong, whatever. That's a 5-minute call. But when somebody's in collections, somebody's delinquent, that's a half-hour call. That's a call of woe is me and gloom and doom, and then the hostility begins. And for a management company, somebody in the back office or the on-site manager, whoever gets that call, they will be crushed by that phone call. And we record all phone calls, and I listen to a lot of phone calls. And from our portal, the management could listen to the phone calls, and so can the board of directors. But again, a lot of administrative work is being relieved from the management company. So the management company, when they get a call about collections, they could say, oh, let me transfer you to our collections department. So right away, the first half hour where they're taking that call, they don't have to take that heat anymore. We'll take it. And believe me, if they get a call for a half hour of hostility and such nastiness that you'll see sometimes, some people are very nice and very cooperative and want to work, but sometimes you'll get those calls that will crush their soul for another half hour. And so what you've just done is you've lost an hour of productive labor from an employee of yours. And even if they were productive, and even if they got everything paid, the management company didn't earn any money. So it's a losing proposition. So we relieve the management company from that burden.
Well, what if you have somebody that's in that position, unit owner, homeowner, and they continue to approach the board, or they continue to contact? Obviously, I know the manager could just turn that phone call, transfer that over to you guys, but what if it's somebody that just I guess 9 times out of 10, if somebody's delinquent, they're not bothering you really. They're just trying to avoid you as much as possible. So maybe you don't see this happen that much, but I would think that you kind of tell them, look, when someone goes into collections, you as a community are not supposed to talk to them about this any further.
Well, that's correct. It's almost as if somebody who is in collections, if they file for bankruptcy, you can't speak to them at all. So if somebody's in collections, you really don't want to speak to them, because if you say the wrong thing, then they may have a claim against you as far as the Fair Debt Collection Practices Act is concerned. So if somebody's in collections and they call, even if they're with an attorney, and an owner calls them and somebody says something to them from the management side that is in violation of the FDCPA, that could be a problem. That could be a problem for the management company. So there's exposure, liability to the management company. It should be in the hands of a professional. It should be in the hands of a collection specialist or a collection agency or an attorney. But management companies should manage, boards of directors should govern, and collection agencies should collect, and lawyers should litigate. Everybody has a place.